Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head back out to Illinois. Big assault weapon ban argument coming up on September 22nd. Might even try to make my way out there if one of you can save me a seat. But we're going to be taking a look at some of the amicus briefs that have been filed in the matter of Barnett v. Raoul. The one we're going to focus on today is a pretty unique argument. It's one that a lot of people out here in the 2A content creator sphere have articulated. It's the first time we've actually seen it used in a legal memorandum, and I kind of want you all to geek out on it with me today. So today, let's spend a few minutes and let's talk about, has the Supreme Court already decided the Illinois assault weapon ban case? Okay, everyone, and especially Illinois, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear, and we are proud to announce our Illinois road trip version 2.0, July 14th through the 18th. We are going to be at all of these locations right here. Now listen, the registration links for all of those are down below, and if you're interested in going, you probably need to sign up pretty soon because spaces are filling up fast. Once again, Washington Gun Law, proud to head out to the land of Lincoln. We will be at these locations on these dates at this time. Registration links down below, brought to us by our good friends at Right to Bear. Okay, America, we are going to head back out to the state of Illinois and a challenge to the Protect Illinois Communities Act, many cases consolidated all under the main named case, which is Barnett v. Raoul, before the 7th Circuit Court of Appeals, now set for oral argument on September 22nd. The amicus brief that we're going to be focusing on today has been authored by the Second Amendment Defense and Education Coalition and the Second Amendment Law Center. And what the authors of this amicus brief are arguing is hey, listen, if we go back and we take a look at what every Supreme Court justice has already said about semi-automatic rifles, AR-15s, any of the firearms that the state of Illinois now wants to label as assault weapons, you know, they've all said these things are in common use. And since they're in common use, that's kind of the end of the inquiry here. The ban is unconstitutional. Now, what the author very creatively did here was take a look at a bunch of recent cases that we've seen decided by the United States Supreme Court. Even took a look at some of the dissenting opinions and what justices had to say about the frequency of those types of firearms. And then even took a look at some of the dissenting opinions on cases in which the petitions were denied, and has come to a conclusion that literally everybody on the current United States Supreme Court has already found that these firearms are in common use. They start their argument this way. Today, in this case, with the additional vertical authority provided in Catano v. Massachusetts, Garland v. Cargill, and Smith & Wesson brands v. Estados Unidos Mexicanos, this court can affirm its place as a vanguard circuit that prioritizes getting the Constitution right. And the argument that the amicus party makes essentially goes like this. Precedent or considered dicta indicates that a majority of the Supreme Court justices already agree that AR-15s are in common use. Through a crude rubric, at least 6 living and 1 recently deceased Supreme Court justices have opined that the semi-automatic rifles at issue in this case are common. In Friedman v. City of Highland Park, the author points out that Justice Thomas, in his dissent to the denial of the petition, had authored, "The city's ban is thus highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes." When one of the Illinois cases made its first run at the United States Supreme Court in the matter of Harold v. Raoul, and that petition was denied, it was once again Justice Thomas who said, "The AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today." Justice Sotomayor, in her dissenting opinion in Cargill v. Garland, referred to these firearms as commonly available. Snope v. Brown, a massive disappointment where the United States Supreme Court decided to turn their back on Maryland's assault weapon ban, in writing not a dissenting an opinion, but kind of a sad sacket of an excuse as to why the case was not being accepted, Justice Kavanaugh wrote, "Given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, Petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment under Heller. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. Recently, in the case of Smith & Wesson v. Mexico, Justice Kagan wrote, AR-15s and AK-47 rifles are both widely legal and bought by many ordinary customers. And so with that and some of the speculation that the Amicus author engages in here, he sums up it this way, that there really are only 3 justices that we don't really know where they're coming down on this, but we can kind of guess. Now, whether he's right or wrong, that remains to be seen, but this is how the Amicus party puts it. The only remaining unknowns on the court who have not expressly adopted the proposition that semi-automatic rifles are in common and lawful use are Chief Justice Roberts, who voted with the majority in Heller, McDonald, Catano, Bruen, Cargill, and Smith & Wesson, Justice Barrett, who voted with the majority in Bruen, Cargill, and Smith & Wesson, and Justice Jackson, who concurred in Smith & Wesson. With a lineup such as this, it is risky for a lower court to buck the obvious trend being set by the higher court. But I know a lot of you sit there and go, yeah, but that's all dicta. It doesn't count. That's not part of the opinion. And I know that's what a lot of people who are advancing the cause of civilian disarmament are arguing. The Amicus Party did some pretty good research and came up with the case of United States v. Bloom, where the whole issue of the persuasiveness of dicta was discussed by the United States Supreme Court when they stated, even if the passage could be called dictum, it is not an aside unrelated to the subject of the case. The question has been briefed by the parties, so the statement was informed rather than casual. It is a considered expression by the court supported by earlier cases that supply more extensive analysis and is not incompatible with any decision before or since. It would ill serve the interest of litigants and the judicial system as a whole to row against the tide of such statements. And they point out that, sometimes those words are placed there for a reason, such as, the court can hear only a small portion of all litigated disputes. It uses considered dicta to influence others for which there is no room on the docket. So a very, very interesting argument where we're just going to take a bunch of justices' own words and say, hey, this is what you said in this case. How can you find any differently? Now, remember, though, the case is before the Seventh Circuit Court of Appeals, who has already found that these types of arms are more appropriate for military use and therefore do not enjoy any Second Amendment protection whatsoever. The case, once again, is Barnett v. Raoul. We're going to link up the Amicus Brief down below so that you can geek out on it for yourself. Remember, our oral arguments are now set for September 22nd. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, all of that information is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.